and welcome to School Psych Podcast. We're super happy tonight to have a special education lawyer chatting with us. I know that our jobs are often very contingent upon legal cases and whatnot for best practices, and we want to make sure that we're doing right legally as well as right by children. So I'm so happy and excited to have him with us tonight. But first off, my name is Rachel. I'm a school psychologist currently working in Maryland. Rebecca?
Hi, I'm Rebecca. I'm a school psychologist working in the state of Connecticut. We really can't wait to hear your questions, thoughts, experiences, ideas tonight. So please feel free to post those questions on either Facebook page, the School Psych Podcast page on Facebook, on Twitter using the hashtag Psyched Podcast, or right alongside this video as you're watching. We're looking forward to hearing from you, and I will definitely be sharing out those questions in our conversation tonight. And here's Anna.
Hi, I'm Anna. I'm a school psych working in New York State. We did a little poll to get some participation on what you guys were interested in, what legal issues you had going on where you work, and we had a huge response. We had 288 respondents in the poll. 22% responded to the qualification of LD as a significant legal issue that they were dealing with. We had a lot of other interest, though, in agreement and disagreement on adequate process, agreement on eligibility, writing legally defensible reports, and school discipline, manifestation determinations. Like, there's lots of legal issues that school psychs out there are dealing with. So I'd like to welcome our special ed lawyer, Lloyd Donders, to our podcast. Thank you so much for joining us, Lloyd. And you are an expert in what we have to deal with.
Thank you so much. I'm really very excited to be here, and I really want to thank all of you, Rachel, Rebecca, and Anna, because I love being able to give these talks, especially to people on the sort of, I don't want to say other side, but on the school district side, because I am a special education attorney. I I represent families of children with special needs. I do a lot of work in New York City, and also I do a lot of work actually for sort of the underrepresented children in New York City who really don't have the finances to be able to support the needs that they have. So I'm really looking forward to having this conversation, and honestly kind of learning from you guys as well, because I am special education attorney. So I know the legal aspects of it, but obviously I don't know so much about the psychological experts that I am not. So I'm very much looking forward to this.
Awesome. So I know that, like Anna said, we had that poll and we got a lot of interest. So I'm thinking we'll start off maybe talking about some of those top things on the poll, which was like the LD and progress. I know New York is an RTI state. So we can start off with that, but I'm really hoping that people are going to be chiming in with questions and topics as Rebecca talked about how to participate and whatnot, and we'll just kind of take it from there and see what you guys want to talk about.
Okay.
Yeah, so can you tell us, Lloyd, about when a family comes to you or when a child is brought to you, as you said, who is maybe not receiving the services that the child's advocate or family believes they should get. What is that process? Are parents seeking you out? Are you close to different school districts? How do you get clients?
Well, that's a good question. It depends. Honestly, a lot of times the sort of paying clients, the clients are parents who have more means, who live more in the suburbs. They usually will seek me out or other special education attorneys because they usually see that there's something going on with their child. They're the first ones who see it, and then they go to the teachers and they ask what can be done, and usually they feel like whatever is getting done is not enough, and they feel like things are just slipping away. So they're the people who actually come to me. But now I try to reach out to parents who aren't quite as savvy. Like I said, in New York City, there's a lot. There are, I believe, over 1 million children in New York City who are in the schools, and something like 212,000 have IEPs. those are the kids who have IEPs. So I try to reach out to them in different ways. I go to different back to school events, churches, and synagogues, and try to make my presence known and try to speak to them and know where they are, because they're less likely to come to me, because a lot of times they just don't understand what their children are entitled to. So that's kind of like a dual approach that I have.
Yeah, that makes sense. And I think it's interesting that from our poll, our respondents, school psychs, we feel one of the most challenging sort of legal aspects of our role is qualifying students with learning disabilities, qualifying versus not. Do you find that that's often a reason that you're called in, that parents or teachers or somebody feels like this child should have qualified, or this child is being qualified, yet we don't think that the assessments suggest that they have a learning disability? Do you come in on that end often?
Absolutely. So I would say the two biggest things that I get parents who come to me and say that my child has issues, the school doesn't think that they have issues, and they're refusing to give my child services. I get a lot of that. I get a lot of, and this might be a little bit more surprising, is that I get a lot of parents coming to me saying my child already has an IEP, is supposed to be getting speech and language and counseling, but my child is not getting what is on the IEP. So I get that quite a lot, where even though they're supposed to get it, they still don't get the services.
Yeah.
That's interesting. And I'm not surprised. I mean, you didn't mention, I know, Rebecca, you brought up like an evaluation being done and the school thinking that there's a problem, but the parents thinking that no. I'm assuming that you're not getting a lot of cases like that, because the parents seem to hold the cards in. If they don't want services, then they don't have to have services, obviously. So.
That's right. And I think that might be a cultural thing. I don't know, because I mean, maybe in certain other areas or different sort of demographic groups, parents might be more averse to having their child labeled as having a disability. And so that kind of depends. I mean, I do have that sometimes, where people don't want their kids labeled. But where I am, they usually don't have as much of an issue. They just want to get their kids services.
Yeah, that makes sense to me. I guess I am consider myself lucky that I haven't met someone like you at work before. But I can see that as a possibility, where a parent and a school district says the child doesn't seem to be making progress or growing in the way that we think that he should be. So let's do an evaluation. And then the parent then says, whoa, you're saying that, you're identifying him with these different qualifications for special ed, and I don't agree with that label, or I don't want that on his record. But, yeah, Rachel, like you said, maybe that's just, that doesn't happen as much as I'm imagining it too.
You talked too about the progress. So as a school psych, I have a hard time, I've worked in RTI districts before, and you're setting a goal where you want to see them make this much progress in this many weeks. And but sometimes I feel like that goal is kind of arbitrary. We're kind of basing it off of, okay, this is what we would expect a typical peer. Well, how do you define that exactly? And so I would imagine that comes into play too. Like how do you determine, or do you see that a lot as a lawyer of, the school thinks that it's sufficient progress, but the parent thinks that it's not, and how do you determine sufficient progress?
Well, those are very good questions. Well, the first thing I would say is in regards to the RTI, and you're probably going to hear this ad nauseum, but school districts cannot use RTI to deny children special education services. They can be done at the same time. So I actually don't come across that a lot, where the district is using RTI to delay, although sometimes it can happen. But what I would tell a parent to do is, if they haven't already, if the child is going through RTI, I would tell them to request an evaluation for special education, because that could kind of get rid of the whole issue of how much progress is being made or not made through RTI, if you can find another classification. But now, as far as how much progress has to be made, yeah, that's the devil's in the details, as they say, because the way the law is down through Rowley, basically, it says that you have to make some progress. Now, what does some progress mean? Well, not to get into too many of the legal details, but some states, well, the country is divided into what's called circuits, which basically divides states up into 13 groupings. Some of the groupings of states have an interpretation of that progress as meaning basically anything more than trivial progress. That's in some of the states. In other states, such as New York, New Jersey, others as well, it has to be meaningful progress. Now, I know these are all kind of like wishy-washy words, but we can all agree that meaningful progress is more than, slightly more than trivial progress. And there's actually a Supreme Court case that has come out of Colorado. What that really happened is the district said, oh, this child is, he's making progress. He's making slightly more than trivial progress. And of course, this kid was making like barely any progress. And they appealed it to the Supreme Court, and that's being heard this year, this term, to determine whether or not should it be meaningful progress? Is it enough to have just slightly more than trivial progress? And depending upon what they come up with, that can have a huge effect on the states. Specifically, can have a huge effect on states that have that trivial progress thing, like Colorado and Texas. But you're still going to have arguments as to how much progress is enough. Usually what I tell people to do is to line up grades and evaluations from year to year. That's the best way to really judge progress. Standardized tests really are the best way, so you can see, what is a standard score from one year to the next, and that's really the best way to determine progress academically. Now, if that's not good enough to make my case, then you look to other areas as well, but that's sort of the easiest black and white that you're looking at.
Can I ask you, Lloyd, that brings to mind a question for me. In these states or anywhere where you're measuring like amounts of progress, wouldn't that whole question be resolved if your IEP goals are really trackable? If they're really good goals, observable goals, specific observable goals, then you can prove progress or not. And you can prove that you are making progress in the way that you set out to make progress, whether that be we want to make trivial progress this semester or we want to make, right?
Right. No, that's true. That's true. But even, and that does have an effect, but whether or not children are meeting their goals, students are meeting their goals, there's some subjectivity there. I mean, obviously, there's be objective, but there's some subjectivity. So the first thing I go to are the standardized tests, because that's just the easiest thing. If a child is getting help in reading, and 1 year in third grade, they're at the, pick something like the 14th percentile, right? And then the next year, I'm looking at the same test, and they're now at the 8th percentile. Well, that's not progress, and that's the easiest thing. And whether or not you're saying, well, Johnny understands 4 out of 5 times that he should do X, Y, and Z, it becomes less relevant than the real numbers. That's the easiest way to really determine it. Mm-hmm. But if you don't have that, then you go to the goals as well. But honestly, I don't use the goals as much, to be honest.
I would think that most of the time on the contentious situations, you're probably dealing with a kid that's maybe not in the special ed system yet, and therefore doesn't have those IEP goals to rely upon. I was
going to get, that's exactly right. Because a lot of the times you're going to be dealing with, is this child making progress? And if not, then we're going to get him qualified for special education. If he is making progress, then you're not going to be qualified. So that's exactly right. A lot of times that's when it comes into play. Mm-hmm.
That's interesting that you're looking at the standardized tests. I mean, when we think standardized tests, at least when I do, I think like a Woodcock-Johnson or a Wyatt or something like that. and comparing the standard score. So if I saw a standard score, for example, that stayed the same, like say I tested this kid 2 years ago and they didn't qualify, or I tested them 3 years ago and now we're due for reevaluation, and we have the same standard scores as we had last cycle, I would think that that is meaningful progress because you're still being compared to your same aged peers. I would, and sometimes parents want to see an increase in those scores, and I have to try and explain that that would mean that they're actually they're making more progress than peers.
Right. Well, that's actually a very good point. However, legally, if the child stays where they are, like the 15th percentile, they haven't made any progress relative to their peers. They've stayed exactly where they are. Sure, maybe their vocabulary's gotten better, but just by aging, your vocabulary is going to get better. But what you need to see is you need to actually see going from 15 to 20, 25%, some sort of progress. If it stays the same, it's not. And where that comes from, it's sort of, it's funny. I used to give a talk, and it's not in play anymore, but the No Child Left Behind. And a lot of people have, a lot of issues with it, and they say, oh, it's terrible. They have testing, too much testing. But No Child Left Behind was really about decreasing the gap. And that was taken into the IDEA. The IDEA incorporated that narrowing the gap. So what that means is that it's not enough for a child to remain at the same level. They need to be having the gap get narrower. So that means they have to make some progress. So, I mean, if the child's 15% and he's at, the next year he's at 20, 25%, and then the parents are like, yeah, but my child's still not at grade level, well, that's too bad. But absolutely, if I had a case where a child was at that 15th percentile and stayed at that percentile, I would be using that for the child's case, because that is not considered to be progress legally.
That's interesting because, I would look at that and think that you're making a year's worth of growth in a year's time because you're growing with your peers. And if you're growing with your peers, I would think, okay, you're good,
Sure.
I see what you're
It's that No Child Left Behind thing. Sometimes it could be a good friend.
I'm interested, and maybe we'll get to it because later, but what you think of the changes coming with ESSA, if those are as positive and hopeful as my sense of them are.
Yeah, I'm really kind of holding out on that. I really, because I don't know what's going to happen. I really can't say. I mean, I don't think it's going to have much of an effect on New York, where I am. I really have concerns about states that don't really provide as much for their children, for their students. And not that New York is an issue, doesn't have that as well. New York City is awful when it comes to providing services. But the thing is that there's relief. As an attorney, I can come in and if I know these students, if I can reach them, I can help them. In some of these other states, I think it's going to be a lot more difficult because the states are now going to start setting their own standards, and it's very tempting to just kind of lower the standards, and then it makes it more difficult for me to argue that a child's not making progress if the expectations are even lower. So I don't know what's going to happen with that. So I'm kind of uneasy about it, but we'll see.
Yeah.
That's it.
Yeah. I'm wondering if maybe we can move in and talk a little bit about manifestations, because that was another big thing that people were curious about, and also just what we can expect as school psychologists at, what should our role be with the manifestations. And then I'm also wondering about if things do go due process in any situation, what are lawyers expecting from school psychs, and what are you guys looking for?
Sure. No, absolutely. Well, just to go, and I just have my notes over here as well, so if you see me looking over. Basically, the one thing I would say, there's several things, but just to kind of quickly go through the process. Districts are not, or schools are not under an obligation to have like one rule fits all. So they really have the ability to judge the unique circumstances on a case-by-case basis. So if a district or a psychologist says, well, you know, this is the case and therefore we need to do X, that's really not sure. I mean, that's not true, because you do have the ability to make, you know, decisions. But basically, so in regards to the manifestation, as you know, if you have a child who is, usually it's some sort of violation of the student code or manual. If they are put into a alternative setting for more than 10 days, if the child has a disability, they are entitled to what we call the manifestation determination review. And then at that point, that's when you have to determine whether the child's behavior is linked to the disability. And I should note this is also for a 504 as well, because you're talking about disability. Although I'm not positive they still call the manifestation determination. They might, but it's very similar. So really, I mean, when I see clients, I tell them with this kind of a situation, you have to be very careful because it's a really serious matter. I tell them, you know, other issues, I might just give them some advice and say, you know, just kind of wing it and see what happens in the CSE meeting. But in this situation, you really need to have an attorney on the parent side. And the first thing I do is I get all the notes and diagnoses and notes from the IEPs to really understand the child's condition and disability. And then I look at what the accusations are and what the behavior was. And I really try to take a look at the two and see where there's overlap. And I'm hoping to see a lot of overlap where it's like, oh, he did this and he has this disability. That makes sense. And then the other thing I do is I bring in an expert as quickly as I can. Because if the child has ADHD, I want to have a psychologist who is like an expert in ADHD who's going to be able to find links between the behavior and the disability. So that's very important too. So that's what you probably, I mean, if it's done the right way, that's probably what you're going to run into, is that you're going to have someone on the other side who is an expert in that particular area of whatever the diagnosis or disability is. So that's where they're going to say. And then, of course, after that, I mean, they're going to look at if there was an FBA, if there was a BIP in place, was it being followed? And those are all factors as well. But I mean, specifically, that my job is to link the two and to try to have an expert say that, yeah, oh, this makes total sense. Of course, this child did this. You know, he's got impulse control, so of course he threw, you know, a pen into this person's eye or whatever. So that's basically my job is to get that link together.
Yeah, that's a tough spot for the school psychologist if the school is saying that it's not a manifestation of his disability and the expert is saying, yes, it is. You're kind of stuck. What would do you have advice for the school psychologist in that example?
Well, I mean, if I'm the attorney from the parent side, my advice to you is just to give in to me personally. But it's difficult. I mean, honestly, if you're in that position, you just have to do your homework. I mean, if you really believe, I mean, you do what's right, obviously, but I mean, if you really don't think there is a connection, then you need to be able to set that out and get that into the record as to why you don't think there's a connection. You want to show that you've really looked at the case, that you've looked at the IEP, if there was a behavioral plan in place, that it was being followed. You really want to make sure that on the record it looks like you've dotted your I's and crossed your T's and did everything you could. Mm-hmm. And ultimately, honestly, I mean, it's going to be the CSE that makes the decision anyway. Mm-hmm. So it's not like a parent hopefully can, or I can hopefully convince whoever is doing the principal or whatever to take my side. But I mean, if they have it in their mind that they're not going to, then there's only so much I can do. So then I'm looking to the appeal process. So that's when I'm going to be looking to really set that up and say, okay, well, they didn't really do their job. You know, they didn't have this implemented. They didn't do this. So the best thing you could do is just try to be as methodical as possible. Ultimately, that's the only thing you can really do until you get higher, above.
Mm-hmm. And does it matter if some of these behaviors happen on the bus as opposed to in school, or like outside of school but on school property? Does that make a difference in these kinds of hearings?
They don't. Actually, it's interesting you say that, because districts and schools have a very large, a lot of latitude as to what they can look at. So if a child has some sort of behavior, a negative behavior on a bus or on a field trip, the school, it makes sense, the school can look to discipline the child. What you may not know is that if something occurs off campus, where maybe a child gets into a fight with another child off the school campus, but that starts coming back onto the school. Maybe there's some cyberbullying going on. Maybe there's like intimidation in the schools. Then the school actually has an authority to reach out and look at what happened off campus. So they do have a pretty wide latitude that way.
That's interesting.
Yeah.
Now, my experience with manifestations, I've often been, when I was in Texas at least, felt that it was a manifestation of the disability, and the administration and the school kind of says no, and I get overruled, and the parent walks out very kind of discouraged. And I have an impulse almost to be like, listen, parent, if you would go and get an attorney or go and get an advocate, or, you would win this.
Right, right.
It kind of puts us like in a hard position there, because you don't know what, and I'm not sure, what is my role there? It probably wouldn't be appropriate for me to go and say, hey, get an attorney. I don't know. What do you suggest?
Yeah, well, it's hard. I mean, do you have tenure or don't you have tenure? And I only half jokingly say that because, I've spoken to school psychologists about issues that students have had, and sometimes I've seen like a deer in the headlights. Like they know there's a problem, but because the special education chairperson is let's just say has a very controlling personality, they're not going to speak out. They're going to say whatever that special education chairperson says for them to do. And sometimes they'll be like, they'll quietly say, you really should get an attorney. You should get someone to get help. So a lot of times it's sort of done, quietly to do that, because, people, they're afraid for their jobs, and I get it, even if you're not going to get fired, people can make your life very difficult. If you're a teacher, you can all of a sudden find out that you're getting classes with kids who are a lot more challenging. So a lot of times, teachers and psychologists would just kind of go behind and be like, you might want to seek some advice from an attorney. Because honestly, there isn't so much more you can do anyway. You're not going to persuade the administrator to change his or her mind, right? So the only thing at that point you can really do would be to just advise the parent to go somewhere else and get more help. So I think that's probably the best thing to do.
Hey, Lloyd, we actually have a question from a viewer that goes back to our earlier conversation about qualification for specific learning disabilities. And she said that you mentioned that a site could possibly look at a different manner in which a district can determine SLD. There is case law which determined a district was within their rights by using RTI methodology rather than further investigating SLD via the discrepancy and PSW models. Do you have a case law to support the notion that RTI districts should use additional methodology to explore a specific learning disability?
Well, actually, first of all, like I was saying before, with the RTI, you can, as a parent, you can still ask for an evaluation, a special education evaluation. So if that's the case, the district is going to be forced to evaluate the child anyway, and see where the child's at. So even with the RTI, that's kind of the issue. Now, with the severe discrepancy, that's kind of interesting, because I was doing a little bit of research on that in a couple of different states, and one of them that popped out was actually Arkansas. And they had a very interesting thing where they said that the state was allowing districts to use one of three ways for evaluating for SLD. One was the RTI, another one was the specific learning discrepancy, and then the third was probably patterns of strengths and weaknesses. And what was interesting is they said to the districts, you can do whichever ones you want, but you can only pick one of them. Now, the reason I say that's interesting is because in the IDEA, it specifically says that you cannot use the discrepancy model. States cannot force the use of the discrepancy model. And that's for all states, all the United States. So the fact that they're giving individual school districts the option to use just this discrepancy model kind of raised flags for me anyway. The other thing that I would say is that in regards to evaluations, you're not supposed to use just one type of evaluation. You're supposed to be using multiple assessments. You're not supposed to rely on any one assessment. So the RTI is just one way of evaluating whether the child is making progress. But what I tell parents to do is just get your child evaluated. Get that done. Show me what the numbers are. Show me the evaluation results. And then we'll go from there, because honestly, the RTI part might just be, it might not be important enough, because if I can get the child classified a different way, then I don't care as much about the RTI. I mean, I want the RTI to work. I mean, I'm not an expert when it comes to teaching. So if you find that the child's making progress with it, that's great. But by getting the child special education services, then it opens the field up. If the RTI doesn't work, you can get additional help here or there. So that's the first thing I do is I try to get the child evaluated. Kind of make an end run around the RTI. And I just want to also say with the specific, the twice exceptional child, because I know that's come up before, and the idea of having more than one type of assessment. Now, as you know, you might know with the twice exceptional child, you're talking about a child that usually has, well, often they have autism, so they could be very high functioning. So their numbers on a Woodcock-Johnson could be pretty high. So very often districts will say, well, look, this child doesn't have any issues. I mean, the child's performing at the 60th percentile, 70th percentile on the Woodcock-Johnson. This looks great. This child doesn't need services. And a lot of parents have a problem. Like, how do I defend that? Well, is you say, well, you can't just use one assessment. And that's by law. There has to be multiple assessments that are looking at the child developmentally, academically, cognitively. So if that one assessment isn't showing that there's a problem, you need to look at other assessments. Or you also have to, when you're looking at the composite assessments, you need to go deeper into there. And you have to see what are the smaller classes of in the evaluations. Really dig into the numbers, because you may average things out, and the child is performing very low here, and then they're performing high here, and it averages out, and then you miss a lot of the issues that are there. I know I see a lot of districts will do that specifically. They'll say, oh, this child's doing just fine if you look at it, but if you really get into the subcategories, you see that the child is not doing well in those areas, and you don't want that to be missed.
Interesting. So our next two next major categories of challenges for school psychs out there were legally defensible report writing, and then also followed by
okay.
Well, followed by a lot. So maybe we'll just start with that. What's your best advice for a legally defensible report? What's the best report that you've had to challenge? And do you have an unidentified copy?
Right. Well, I mean, first, look, the first thing you want to do, and this should be pretty obvious, is that, you want to make sure that the assessments are done by qualified persons. Okay, people who are qualified to do the tests. That's the first thing I'm going to look at. How many times has this person done the test? How familiar are they with it? So that's the first thing you really want to do. You want to make sure that you assess all areas of the suspected disability, and it doesn't have to be necessarily what you would expect from the disability. So, maybe if a child has autism, did you look at whether the child has speech and learning issues? Or did you look to see if the child has ED issues? So I'm looking to see if that's been complete. If that's been done, I'm looking to see whether you're only relying upon one assessment. Are you only looking at the Woodcock-Johnson? Are you only looking at one type of assessment, or are you bringing other assessments in? Did you do an observation of the child? Did you speak with the parents? Did you do, whether it's a Connors or a Basque? Did you get feedback from them? What else am I looking for?
That's making me think though too. I've heard different things about some psychs are hesitant to write lengthy reports because they feel like there's more that can be nitpicked and challenged. And then I've heard also psychs say, no, be as thorough as you can and kind of leave no stone unturned, which is the best route.
You're better off being more thorough. You really are, because you have to understand, because you're doing all these assessments, okay? And if one of the assessments, like let's say you don't think a child should be classified as needing a special education, you do all these assessments. If you do one assessment that shows that, yeah, this child definitely really looks like this child needs special education, but you've done 10 others that show that he doesn't, yeah, I'm going to try to harp on that one that helps me harder, because you've got all these others showing otherwise. So I wouldn't really concern, and honestly, if you don't do that report as thoroughly, because you're afraid, then I'm going to do it anyway. I'm going to get the child evaluated myself. And again, this is if the child has a representative. I'm going to do the evaluation myself. I'm going to get an expert from the Huntington Learning Center or someplace to do an educational. I'm going to have an OT do it. I'm going to have someone else do a different portion of it. So even if you don't do it, I'm going to have it done anyway. So you're better off. The fact that you do more of it also shows that you are considering more assessments, and you're really taking this seriously, and it's not a one-size-fits-all. So it looks a lot better for you to be able to do that.
Okay. Those are really good tips. I liked. I mean, I always do an observation just to kind of cover, even if it's an LD thing and there's no behavior concerns. I still want to see how they handle that and document that. But and you brought up outside, that you're going to request, I guess, that independent eval, or you're going to get somebody else to do an evaluation. So talk to us a little bit about outside evals and what the school's responsibility and our responsibility for considering that and using that and recommendations from outside psychs.
Sure. Well, by law, if once you do an evaluation, and I should clarify that an evaluation covers all the assessments. So when you do, let's say, an initial evaluation, because I saw someone was asking what's an evaluation. The evaluation isn't the Woodcock-Johnson, okay? The evaluation is the Woodcock-Johnson, the Connors, the OT assessment. These all turn into the evaluation. So it's not just one. Because once you do your evaluation, the parent has a right to say, I don't agree with the evaluation. I want to get an independent, impartial educational evaluation. You put in a request to the school. Now, at that point, the school has two options. The school can either say, sure, that's fine. We'll give you a list of people you can use. This is, or they could say, no, we're not going to give it to you. But the only way they can do that is to actually take the parent to due process. So the burden is really on the schools in that way. So usually they're going to give the allow for the IEE. Now, once that happens, the parent's going to go wherever they deem is best, and generally speaking, the evaluation they get is probably going to be more favorable to the child. Not always, but probably. So then what you're going to have to do is you're going to have the evaluation at the CSE meeting. And legally, you are required to consider any independent evaluation that the parent brings in. So that includes evaluations whether the parent paid out of pocket for it. You're supposed to consider that evaluation. So if you're sitting with the parent's evaluation and you're sitting with your evaluation, if you want to do things right, you need to at least consider the parent's evaluation. If you don't even discuss it, that's what I'm looking for. I'm looking for something where you're not even considering this other evaluation. Because later on in due process, you can say, well, yeah, we looked at it, but we think that ours was correct. And I'm like, all right, well, show me in the minutes where you were actually discussing it. Where were you discussing it? Okay, you can say that you think yours is better than this, but you still have to look at it. And that's kind of hard to say if you haven't even, cracked open the binder on it. So that's kind of the advice that I would have with that.
So I have seen my share of outside evaluations, and some of them I've just judged poorly. Sometimes they give tests that are like grossly outdated. Like you're supposed to stop using a test like a year after the new version comes out, and they're giving these really outdated tests, and they're writing these 40-page reports, and it's like,
Wait,
it's garbage.
Is this independent, you're saying, or in your district?
Yeah. Independent evaluations that parents find on their own, people out there who are doing these things. Do you kind of guide parents towards certain evaluators that seem legit? Like, I just feel bad sometimes reading these reports that parents paid an arm and a leg for that are 40 pages long that are useless, in my opinion.
Yeah, I usually advise them to go to certain ones that I know that I feel comfortable with. Because honestly, the bad evaluations don't usually cost that much less than the good ones. So I will usually guide them and be like, use one of these people. If they come to me, sometimes they do it themselves. So it's after they've done it, and then I look at the evaluation and I'm kind of confronted with, well, maybe we need to get another one. And and a parent is only entitled to one to be paid by the district. So that gets a little bit troublesome, unfortunately, but that's sometimes what you have to deal with, I guess. Yeah.
And I've totally been in a situation where we've received something like that, a very outdated test, some psychobabble nonsense that's not supported by research. And my district ended up taking that and reporting it to the psych board and following up with that to make sure that psych stopped doing what they were doing. So
yeah, that's not helping anyone, certainly. No.
So we want to talk about behavior plans and best practice. Do you have any tips for us? A lot of times we're the ones who are writing these plans. We might have some sort of outline that our district provides. We might be kind of winging it. What are your tips for behavior plans?
Well, honestly, I don't have as many tips for that because that tends to be more your job and more your expertise. I mean, basically, the only tips I would really give is that you're starting out. You want to make sure that you have a very thorough functional behavioral assessment and really look at all the concerns that you see, that the parent sees, that the teachers see, and really try to address those issues into some sort of a BIP with positive interventions. That's really more about the process and about what you're doing to address the issues and what you're seeing. I don't have too much advice because when it comes to those plans, a lot of times what I'm dealing with is there wasn't a BIP put into place. A child, is on the spectrum, has these behavioral issues, and there was no FBA done or no BIP done at all. So I come across that a lot. Or obviously in the manifestation determination, you'll see that the FBA wasn't adequate enough because it wasn't addressing the behaviors. There isn't too much more I can give for that.
If you see certain things, maybe do a behavior plan, like you mentioned, manifestation hearings, like if there's a child being violent, would you recommend a behavior plan? You know, at some point,
Oh my
being
goodness,
removed
yes.
from special ed, we would do a behavior plan at some point.
Oh, absolutely. I mean, if you have a child who's aggressive, and I mean, if you think he's going to be violent, something else. But I mean, certainly, if you're finding the child is aggressive, I mean, you should have that child have an assessment and put into some sort of a plan. Because honestly, I mean, well, first of all, the child needs it, right? I mean, you're going to be able to have some intervention. And, you know, look, I don't want a child who is violent, no matter what you do, to go back into the general population. That's not what we're looking for, you know. As attorneys for parents and for the students, we want to do the most that we can to keep children in the least restrictive environment. And you guys are psychologists, so you understand that there are behavioral plans that you can put into place that can make it more likely that you can keep a child in a general educational setting. Now, if you're doing everything you can and the child is still aggressive and is still violent, well, at that point, we should be looking at a different setting. So I want you to be doing that correctly. You know, honestly, I mean, I want that to be done because, you know, I don't blame children. You know, the children have the issues that they have. So if you do everything you can behaviorally and it's not working, then that setting's not right for the child. And we're going to have to look at a different setting, a different school, or whatever it is. So please, you know, do more of that. That's it. I don't like the us versus them when it comes to that, certainly.
Yeah, and maybe not to throw in an us versus them, but one of the other points on the poll that people found frustrating were when they came up with a plan, maybe a behavior plan, and teachers didn't follow the recommendations. So in those kinds of cases, when parents are saying there's not adequate progress, or you're not doing the right thing by my child, but the psych is doing everything they can and the teachers aren't following through, is there any advice in that kind of situation? What do you do for parents in a case like that?
Well, what do I do? Well, first
Yes.
of all, if I see that the psychologist is doing everything that he or she is doing, it's not their fault. Mm-hmm. So I wouldn't hold that against them. If I see the teachers aren't following through with it, well, it's their fault, probably. Mm-hmm. But one thing I know for a fact is it's not the child's fault.
Right.
So I'm going to get the child what she needs. So what can you do? There isn't much you can do. I mean, aside from trying to get the teachers to do what they're supposed to do, or going to people above them to say that the teachers aren't following through. And if this happens, you know, quite honestly, it's going to cost us more money. Not that we should be talking money, but it's going to cost us more services because they're not doing what they should be doing. But there isn't too much else you can do because I'm there for the child. So whether it's psychologist that's doing something wrong, the teacher that's doing something wrong, whatever it is, all I care about is the student getting what's right. So that's what that is, really.
Yes, I agree. That's a tough one. Trying to get everyone on the team on the same page sometimes is tough, but we can do it. So do we have any last questions? I'm not seeing any questions out here on our interweb sites. You had, you know, one great motivational line of advice for your school psychologist friends out there, Lloyd. What might you say?
What I would say is, honestly, just do what's right for the child. And it's about the process, and it's about doing the full assessments and really trying to get at what the issues the child has or doesn't have. You're going to have people argue with you no matter what, whether it's the administrator saying this child shouldn't get services or the parents who say this child should get services. And the best thing to do, I mean, you're there for the child. So you just want to get to the bottom of whether the child has issues or not. And as best you can, try to put the other stuff out of your mind, which is easier said than done, I know. But that's really the most that I can ask from, you know, the psychologist. And don't be afraid to ask questions. You know, I mean, there's a lot of stuff out there. So, I mean, honestly, a lot of the issues that have come up, I actually have not to self-promote too much, but I have a blog where I cover some of these topics. I try to do it in a concise way because they can get kind of crazy to look at it. But I have definitely had things on manifestation determinations and independent evaluations and twice exceptional children. I try to make it fairly brief, but that actually answers a lot of the questions that have come up here. So certainly feel free to take a look at that as well.
Can you plug it? What's the website again?
Well, actually, my website is specialedlegalinfo.com. Or on
blog as well.
What's that?
You said there was a blog. Is the blog the website? Sorry.
Yeah, the blog is on the website. And then I also will post on Facebook. You just look up the law offices of Lloyd Donders, and you'll see my Facebook there. And I put up a lot of links to my blog entries as well. So
I'm following.
So school psychs by nature, I think we're kind of like thorough type A badasses. I like to think so. So we just need to keep being child-centered and keep being thorough and do what's best for the child. And even if it takes more time for us to do it, we'll be doing right in the end, it sounds like.
And ask questions, because I mean it's very common for non-legal people to not know what the laws actually are, and you might think one thing when the law says something else, and you just wouldn't know. So don't be afraid to ask questions if you really want to find out. Really.
Great. We just have one question under the gun. If I could squeeze it in just before we wrap up. Somebody's asking, what happens when a child is diagnosed with anxiety due to the treatment from the one-to-one aid, and every time this child has to work with her, he turns aggressive? It sounds like a very complicated and unfortunate situation.
Right. Well, that's very interesting. I mean, I would start by changing the aid.
Yes.
I mean, honestly, if the child has a one-to-one aid, and he's obviously getting special education, so we're probably not going to be needing another diagnosis for classification for anxiety. But really, I mean, just change the aid, because legally you can set yourself up for some liability. That's probably not going to be done by me. But if the child really starts having a great deal of anxiety due to someone who works at your school, you may have some other legal consequences as well. And certainly the child's not going to be making adequate academic progress if they have that much of an issue and they start having anxiety. So it's just bad all over.
Yes. Well, thanks for responding to that one. That's a tough one.
And thank you so much for coming on. And I know that we could go on and on and on and keep you here for like 5 hours with questions. So maybe one day in the future we can snag you back and try and convince you to do a second episode. We would love that.
Absolutely.
Thank
you so much.
It'd be my pleasure. And so I just want to mention before we sign off, I think it looks like our next podcast is scheduled for 12/18, and we're looking to have Dr. Shaw on and speaking about applying evidence-based practices is what's kind of tentatively on the schedule at this point. So we'll be looking forward to that. Thank you everybody for participating, and thank you again.
Yeah, thank you, Lloyd, for your hour of legal advice. It was amazing.
The bill will be in the mail.
Good night.